Hello everyone, my name is Satyam Shivaach and I am working as a legal intern with LEXIS and Company. And in this video, we will discuss about Transfer of Property Act. Under the Indian legal system, properties are divided into two categories. First is movable and second is immovable. The Transfer of Property Act 1882, which came into force on 1st July, deals with the aspect of transfer of property between living beings. One of the oldest law in the Indian legal system, the Transfer of Property Act is an extension of the law of the contract and runs parallel to the succession law. For those who are planning to transfer their immovable property, there are some key aspects which should be taken into consideration. Let's see what are the scope of Transfer of Property Act. A transfer of property can be effectuated by act of two or more parties or an act by the operation of the law. The Transfer of Property Act is applicable primarily on transfer of immovable properties from one living being to another. Also, the Act is applicable on the property of transfer of property by individual as well as by the companies. However, the transfer of property is applicable to acts of parties and not on transfer applicable by the law. Now, what does transfer of property signify? The term transfer includes transfer through sales, mortgage, lease, exchangeable claim, gift or exchange. The Act does not cover transfer by operation of law in the form of inheritance, forfeiture, insolvency or sale through the execution of a decree. The Act is also not applicable on the disposal of properties through wills and does not deal in cases of succession of property. Now, what are the types of properties which can be transferred under this Act? The transfer of property talks about 6 types of property. First being sales, second being lease, third being mortgage, fourth being exchange, fifth being gift, sixth being actionable claim. Now, who can transfer the property? Section 7 of this Act deals with the legality and comply with the people who are eligible to transfer the property. Every person condemned to contract and entitled to transfer property or authorized to dispose or transfer property not his own, incompetent to the transfer such property, either wholly or in part, or either absolutely or conditionally, in the circumstances to the extent and in manner allowed by the prescribed law. The section reads under the Contract Act, a person who is at least 18 years of age and have a sound mind is eligible to get into a contract, and the same person will be eligible to make a transfer. Now, what are the properties that cannot be transferred under the Transfer of Property Act? The term of immovable property, one cannot transfer a property that one expects to inherit in future. The lessor cannot transfer his right to re-entry into leased property. Under the Transfer of Property Act, a real estate developer who has entered into a joint development agreement with a landowner to build a project on the latter's land is not allowed to transfer the ownership of the project thus created under the provision of Transfer of Property Act. The implications are restricted not only to the development part of the project. The builder will have to get a general power of attorney in order to sell the project on the behalf of the owner. Even in the scenario of the landowner, there will be one providing the convenience due to the prospective buyer of the project. The Act also prohibits the transfer of easement right, the right to use someone else's land or property in some way. These include the right of way of passage, right of light, a right of water, or etc. One can also not transfer one's property which can be inherited and restricted in its enjoyment. A right to future maintenance is only for the personal benefit of the person to whom it has been granted. Hence, the right cannot be transferred. A tenant having a non-transferable right of occupancy cannot alienate or assign his interest in the occupancy. Similarly, a farmer or an estate that has defaulted in paying revenue cannot assign his interest in the holding. The same is true as a lessee of an estate under the management of a court or ward. The transfer of property through verbal agreement. Section 9 of the Act says property transfer could be effected through an oral agreement unless the law explicitly states that it has to be in written agreement and must be prepared to conclude the transaction. In the case of immovable property of value of less than 100 rupees, such transfer may be made either through a registered instrument or by delivery of the property. However, oral agreement do not typically work except for partition of the property, where the family members can get into a verbal agreement and divide the property for the practical purposes. Exchange of property often requires written agreement for the transaction to be legally void. This is true for sale, gift, leases, etc. Now, let's talk about transfer of property to an unborn child. A person who is planning to bequeath his property to more generation than one will have to keep the provision of transfer of property in mind while doing so. This becomes imperative to avoid legal complication at a later stage. Under the provision made in Section 13 and 14 of the Transfer of Property Act, the transfer of property directly in favor of an unborn child is prohibited. For this to happen, the person intending to make a transfer will first have to transfer it in favor of a person who is alive on the date of transfer. The property will have to vest in the name of the person till the time that the unborn child comes into the existence. Basically, the interest of the unborn child in the property must be preceded by the legal person or a prior person with a prior interest. Now, what are the responsibilities of a seller during the transfer of property? Section 54 of the Act talks about the responsibility of the seller of a property. First being to disclose to the buyer any material defect in the property, followed by to provide the buyer on the request of examination of the documents of title relating to the property, or to answer to the best of his information all relative question put to him by the buyer with respect to the property of the title, and to execute a proper convenience of the property when the buyer tender it to him for execution at the proper time and place, on payment on tender of the amount due in the respect of the price, to take as much care of the property and all the documents which are in possession as the owner of ordinary prudence would take such a property between the date of the contract and sale of the delivery contract. Also, to give the buyer possession of the property when there is need, and to pay all the public charges and rent accrued with respect to the property up to the date of the sale. And the last is to discharge all the encumbrance on the property then existing. Now let's see the final topic of this video. What are the duties of the buyer during the transfer of the property? Starting with disclosing the seller any fact about the property of which the buyer is aware of but has reason to believe that the seller is not aware, and which materially increases the value of such interest. Moreover, it is necessary to pay the purchase money to the seller at the time and place of completing the sale, and to bear any losses arising from the destruction, injury, or decrease in value of the decrease in the property and not caused by the seller when the ownership of the property has passed on to the buyer. And the last is to pay all the public charges and rent which may become payable on the property, the principal monies due to the encumbrance subject to which the property is sold, and the interest thereupon awards accruing due where the ownership of the property has passed on to the buyer. That is all for today's video. Thank you for watching. Please like, share and subscribe.